Hello, everyone. Today's case is a pretty famous one. This one is Reynolds v. Sims. So this one was about apportionment for I think it was senators, and it was like, do you represent land or people? So let's see what the Supreme Court said. Charging that malapportionment of the Alabama legislature deprived them and others similarly situated of rights under the Equal Protection Clause of the 14th Amendment and the Alabama Constitution. Voters in several Alabama counties brought suit against various officials having state election duties. Complainants sought a declaration that the existing state legislative apportionment provisions were unconstitutional, an injunction against future elections pending reapportionment in accordance with the state constitution, or, absent such reapportionment, a mandatory injunction requiring holding the 1962 election for legislatures at large over the entire state. The complaint alleged serious discrimination against voters in counties whose populations had grown proportionately far more than others since the 1900 census, which, despite Alabama's constitutional requirements for legislative representation based on population and for decennial reapportionment, formed the basis for the existing legislative apportionment. Pursuant to the 1901 Constitution, the legislature consisted of 106 representatives and 35 senators for the state's 67 counties and senatorial districts. Each county was entitled to at least one representative. Each Senate district could have only one member, and no county could be divided between two Senate districts. A three-judge federal district court declined ordering the May 1962 primary election to be held at large, stating that it should not act before the legislature had further opportunity to take corrective measures before the general election. Finding after a hearing that neither of the two apportionment plans, which the legislature thereafter adopted to become effective in 1966, would cure the gross inequality and invidious discrimination of the existing representation, which all parties generally conceded violated the Equal Protection Clause, and that the complainants' votes were unconstitutionally debased under all of the three plans at issue. The district court ordered temporary reapportionment for the 1962 general election by combining features of the two plans adopted by the legislature, and enjoined officials from holding future elections under any of the invalid plans. The officials appealed, claiming that the district court erred in holding unconstitutional the existing and proposed reapportionment plans, and that a federal court lacks power affirmatively to reapportion a legislature. Two groups of complainants also appealed, one claiming error in the district court's failure to reapportion the Senate according to population, the other claiming error in its failure to reapportion both houses of on a population basis. Held. The right of suffrage is denied by debasement or dilution of a citizen's vote in a state or federal election. Under the Equal Protection Clause, a claim of debasement of the right to vote through malapportionment presents a justiciable controversy, and the Equal Protection Clause provides manageable standards for lower courts to determine the constitutionality of a state legislative apportionment scheme. The Equal Protection Clause requires substantially equal legislative representation for all citizens in a state regardless of where they reside. Legislatures represent people, not areas. Weighting votes differently according to where citizens happen to reside is discriminatory. The seats in both houses of a bicameral legislature must, under the Equal Protection Clause, be apportioned substantially on a population basis. The district court correctly held that the existing Alabama apportionment scheme and both of the proposed plans are constitutionally invalid since neither legislative house is or would thereunder be apportioned on a population basis. The superficial resemblance between one of the Alabama apportionment plans and the legislative representation scheme of the federal Congress affords no proper basis for sustaining that plan, since the historical circumstances which gave rise to the congressional system of representation arising out of compromise among sovereign states are unique and without relevance to the allocation of seats in state legislatures. The federal constitutional requirement that both houses of a state legislature must be apportioned on a population basis means that, as nearly as practicable, districts be of equal population, though mechanical exactness is not required. Somewhat more flexibility may be constitutionally permissible for state legislative apportionment than for congressional districting. A state legislative apportionment scheme may properly give representation to various political subdivisions and provide for compact districts of contiguous territory if substantial equality among districts is maintained. Some deviations from a strict equal population principle are constitutionally permissible in the two houses of a bicameral state legislature, where incident to the effectuation of a rational state policy, so long as the basic standard of equality of population among districts is not significantly departed from. Considerations of history, economic, or other group interests or area alone do not justify deviations from the equal population principle. Ensuring some voice to political subdivisions in at least one legislative body may, within reason, warrant some deviations from population-based representation in state legislatures. In admitting states into the Union, Congress does not purport to pass on all constitutional questions concerning the character of state governmental organization, such as whether a state legislature's apportionment departs from the equal population principle. In any case, congressional approval could not validate an unconstitutional state legislative apportionment. States consistently with the Equal Protection Clause can properly provide for periodic revision of reapportionment schemes, though revision less frequent than decennial would be constitutionally suspect. Courts should attempt to accommodate the relief ordered to the apportionment provisions of state constitutions as far as possible, provided that such provisions harmonize with the Equal Protection Clause. A court, in awarding or withholding immediate relief, should consider the proximity of a forthcoming election and the mechanics and complexities of election laws, and should rely on general equitable principles. The district court properly exercised its judicial power in this case by ordering reapportionment of both houses of the Alabama legislature for purposes of 1962 elections as a temporary measure by using the best parts of the two proposed plans, each of which it had found as a whole invalid, and in retaining jurisdiction while deferring a hearing on the issuance of a final injunction to give the reapportioned legislature an opportunity to act effectively. Mr. Chief Justice Warren delivered the opinion of the court. Let me back up for a second. To give a reapportioned legislature an opportunity to act effectively. Affirmed and remanded for further proceedings. All right, Mr. Chief Justice Warren delivered the opinion of the court. Involved in these cases are an appeal and two cross appeals from a decision of the Federal District Court for the Middle District of Alabama, holding invalid under the Equal Protection Clause of the Federal Constitution the existing and two legislatively proposed plans for the apportionment of seats in the two houses of the Alabama legislature, and ordering into effect a temporary reapportionment plan comprised of parts of the proposed but judicially disapproved measures. On August 26, 1961, the original plaintiffs, appellees in number 23, residents, taxpayers, and voters of Jefferson County, Alabama, filed a complaint in the United States District Court for the Middle District of Alabama, in their own behalf and on behalf of all similarly situated Alabama voters, challenging the apportionment of the Alabama legislature. Defendants below, appellants in number 23, sued in their respective capacities, were various state and political party officials charged with the performance of certain duties in connection with state elections. The complaint alleged a deprivation of rights under the Alabama Constitution and under the Equal Protection Clause of the 14th Amendment, and asserted that the district court had jurisdiction under provisions of the Civil Rights Act, 42 U.S.C. subsections 1983, 1988, as well as under 28 U.S.C. subsection 1343-3. The complaint stated that the Alabama legislature was composed of a Senate of 35 members and a House of Representatives of 106 members. It set out relevant portions of the 1901 Alabama Constitution, which prescribed the number of members of the two bodies of the state legislature and the method of apportioning the seats among the state's 67 counties, and provide as follows. Article 4, Section 50. The legislature shall consist of not more than 35 senators and not more than 105 members of the House of Representatives, to be apportioned among the several districts and counties as prescribed in this Constitution, provided that in addition to the above number of representatives, each new county hereafter created shall be entitled to one representative. Article 9, Section 197, the whole number of senators shall be not less than 1/4 or more than 1/3 of the whole number of representatives. Article 9, Section 198, the House of Representatives shall consist of not more than 105 members unless new counties shall be created in which in which event each new county shall be entitled to one representative. The members of the House of Representatives shall be apportioned by the legislature among the several counties of the state according to the number of inhabitants in them, respectively, as ascertained by the decennial census of the United States, which apportionment, when made, shall not be subject to alteration until the next session of the legislature after the next decennial census of the United States shall have been taken. Article 9, Section 199, it shall be the duty of the legislature at its first session after the taking of the decennial census of the United States in the year 1910, and after each subsequent decennial census, to fix by law the number of representatives and apportion them among the several counties of the state, according to the number of inhabitants in them respectively, provided that each county shall be entitled to at least one representative. Article 9, Section 200, it shall be the duty of the legislature at its first session after taking of the decennial census of the United States in the year 1910, and after each subsequent decennial census, to fix by law the number of senators and to divide the state into as many senatorial districts as there are senators, which districts shall be as nearly equal to each other in the number of inhabitants as may be, and each shall be entitled to one senator, and no more, and such districts, when formed, shall not be changed until the next apportioning session of the legislature, after the next decennial census of the United States shall have been taken, provided that counties created after the next preceding apportioning session of the legislature may be attached to senatorial districts. No county shall be divided between two districts, and no district shall be made up of two or more counties not contiguous to each other. Article 18, Section 284, representation in the legislature shall be based upon population, and such basis of representation shall not be changed by constitutional amendments. The maximum size of the Alabama House was increased from 105 to 106 with the creation of a new county in 1903, pursuant to the constitutional provision which states that, in addition to the prescribed 105 House seats, each county thereafter created shall be entitled to one representative. Article 9, subsections 202 and 203 of the Alabama Constitution established precisely the boundaries of the state's senatorial and representative districts until the enactment of a new reapportionment plan by the legislature. These 1901 constitutional provisions, specifically describing the composition of the senatorial districts and detailing the number of House seats allocated to each county, were periodically enacted as statutory measures by the Alabama legislature, as modified only by the creation of an additional county in 1903, and provided the plan of legislative apportionment existing at the time this litigation was commenced. Plaintiffs below allege that the last apportionment of the Alabama legislature was based on the 1900 federal census, despite the requirement of the state constitution that the legislature be reapportioned decennially. They asserted that since the population growth in the state from 1900 to 1960 had been uneven, Jefferson and other counties were now victims of serious discrimination with respect to the allocation of legislative representation. As a result of the failure of the legislature to reapportion itself, plaintiffs asserted they were denied equal suffrage in free and equal elections, and the equal protection of the laws, in violation of the Alabama Constitution and the 14th Amendment to the federal Constitution. The complaint asserted that plaintiffs had no other adequate remedy, and that they had exhausted all forms of relief other than that available through the federal courts. They alleged that the Alabama legislature had established a pattern of prolonged inaction from 1911 to the present, which clearly demonstrates that no reapportionment shall be effected, that representation at any future constitutional convention would be established by the legislature, making it unlikely that the membership of any such convention would be fairly representative, and that while the Alabama Supreme Court had found that the legislature had not complied with the state constitution in failing to reapportion according to population decennially, that court had nevertheless indicated that it would not interfere with matters of legislative reapportionment. Plaintiffs requested that a three-judge district court be convened. With respect to relief, they sought a declaration that the existing constitutional and statutory provisions establishing the present apportionment of seats in the Alabama legislature were unconstitutional under the Alabama and federal constitutions, and an injunction against the holding of future elections for legislatures until the legislature reapportioned itself in accordance with the state constitution. They further requested the issuance of a mandatory injunction effective until such time as the legislature properly reapportioned, requiring the conducting of the 1962 election for legislators at large over the entire state, and any other relief which may seem just, equitable, and proper. A three-judge district court was convened, and three groups of voters, taxpayers, and residents of Jefferson, Mobile, and Etowah counties were permitted to intervene in the action as intervener plaintiffs. Two of the groups are cross appellees in numbers 27 and 41. With minor exceptions, all of the interveners adopted the allegations of and sought the same relief as the original plaintiffs. On March 29, 1962, just 3 days after this court had decided Baker v. Carr, plaintiffs moved for a preliminary injunction requiring defendants to conduct at large the May 1962 Democratic primary election and the November 1962 general election for members of the Alabama legislature. The district court set the motion for hearing in an order stating its tentative views that an injunction was not required before the May 1962 primary election to protect plaintiffs' constitutional rights, and that the court should take no action which was not absolutely essential for the protection of the asserted constitutional rights before the Alabama legislature had a further reasonable but prompt opportunity to comply with its duty under the Alabama Constitution. On April 14, 1962, the district court, after reiterating the views expressed in its earlier order, reset the case for hearing on July 16th, noting that the importance of the case, together with the necessity for effective action within a limited period of time, required an early announcement of its views. Relying on our decision in Baker v. Carr, the court found jurisdiction, justiciability, and standing. It stated that it was taking judicial notice of the facts that there had been population changes in Alabama's counties since 1901, that the present representation in the state legislature was not on a population basis, and that the legislature had never reapportioned its membership as required by the Alabama Constitution. Continuing, the court stated that if the legislature complied with the Alabama constitutional provision requiring legislative representation to be based on population, there could be no objection on federal constitutional grounds to such an apportionment. The court further indicated that if the legislature failed to act, or if its actions did not meet constitutional standards, it would be under a clear duty to take some action on the matter prior to the November 1962 general election. The district court stated that its present thinking was to follow an approach suggested by Mr. Justice Clark in his concurring opinion in Baker v. Carr, awarding seats released by the consolidation or revamping of existing districts to counties suffering the most egregious discrimination, thereby releasing the stranglehold on the legislature sufficiently so as to permit the newly elected body to enact a constitutionally valid and permanent reapportionment plan, and allowing eventual dismissal of the case. Subsequently, plaintiffs were permitted to amend their complaint by adding a further prayer for relief, which asked the district court to reapportion the Alabama legislature provisionally so that the rural stranglehold would be relaxed enough to permit it to reapportion itself. On July 12, 1962, an extraordinary session of the Alabama legislature adopted two reapportionment plans to take effect in the 1966 elections. One was a proposed constitutional amendment referred to as the 67 Senator Amendment. It provided for a House of Representatives consisting of 106 members, apportioned by giving one seat to each of Alabama's 67 counties and distributing the others according to population by the equal proportions method. Using this formula, the constitutional amendments specified the number of representatives allotted to each county until a new apportionment could be made on the basis of the 1970 census. The Senate was to be composed of 67 members, one from each county. The legislation provided that the proposed amendment should be submitted to the voters for ratification at the November 1962 general election. The other reapportionment plan was embodied in a statutory measure adopted by the legislature and signed into law by the Alabama governor, and was referred to as the Crawford-Webb Act. It was enacted as standby legislation to take effect in 1966 if the proposed constitutional amendment should fail of passage by a majority of the state's voters, or should the federal courts refuse to accept the proposed amendment, though not rejected by the voters, as effective action in compliance with the requirements of the 14th Amendment. The act provided for for a Senate consisting of 35 members representing 35 senatorial districts, established along county lines, and altered only a few of the former districts. In apportioning the 106 seats in the Alabama House of Representatives, the statutory measure gave each county one seat and apportioned the remaining 39 on a rough population basis under a formula requiring increasingly more population for a county to be accorded additional seats. The Crawford-Webb Act also provided that it would be effective until the legislature is reapportioned according to law, but provided no standards for such a reapportionment. Future apportionments would presumably be based on the existing provisions of the Alabama Constitution, which the statute, unlike the proposed constitutional amendment, would not affect. The evidence adduced at trial before the three-judge panel consisted primarily of figures showing the population of each Alabama county and senatorial district according to the 1960 census, and the number of representatives allocated to each county under each of the three plans at issue in the litigation. The existing apportionment under the 1901 constitutional provisions and the current statutory measures substantially reenacting the same plan. The proposed 67 senator constitutional amendment and the Crawford-Webb Act, under all three plans, each senatorial district would be represented by only one senator. On July 21, 1962, the district court held that the inequality of the existing representation in the Alabama legislature violated the Equal Protection Clause of the 14th Amendment, a finding which the court noted had been generally conceded by the parties to the litigation since population growth and shifts had converted the 1901 scheme, as perpetuated some 60 years later, into an invidious discriminatory plan completely lacking in rationality. Under the existing provisions applying 1960 census figures, only 25.1% of the state's total population resided in districts represented by a majority of the members of the Senate, and only 25.7% lived in counties which could elect a majority of the members of the House of Representatives. Population variance ratios of up to about 41-1 existed in the state, and up to about 16-1 in the House. Bullock County, with a population of only 13,462, and Henry County, with a population of only 15,286, each were allocated 2 seats in the Alabama House, whereas Mobile County, with a population of 314,301, was given only 3 seats, and Jefferson County, with 634,864 people, had only 7 representatives. With respect to senatorial apportionment, since the pertinent Alabama constitutional provisions had been consistently construed as prohibiting the giving of more than one Senate seat to any one county, Jefferson County, with over 600,000 people, was given only 1 senator, as was Lowndes County, with a 1960 population of only 15,417, and Wilcox County with only 18,739 people. The court then considered both the proposed constitutional amendment and the Crawford-Webb Act to ascertain whether the legislature had taken effective action to remedy the unconstitutional aspects of the existing apportionment. In initially summarizing the result which it had reached, the court stated, "This court has reached the conclusion that neither the 67 Senator Amendment nor the Crawford-Webb Act meets the necessary constitutional requirements. We find that each of the legislative acts, when considered as a whole, is so obviously discriminatory, arbitrary, and irrational that it becomes unnecessary to pursue a detailed development of each of the relevant factors of the federal constitutional test." The court stated that the apportionment of 1 senator to each county under the proposed constitutional amendment would make the discrimination in the Senate even more invidious than at present. Under the 67 Senator Amendment, as pointed out by the court below, the present control of the Senate by members representing 25.1% of the people of Alabama would be reduced to control by members representing 19.4% of the people of the state. The 34 smallest counties, with a total population of less than that of Jefferson County, would have a majority of the senatorial seats, and senators elected by only about 14% of the state's population could prevent the submission to the electorate of any future proposals to amend the state constitution, since a vote of 2/5 of the members of one house can defeat a proposal to amend the Alabama Constitution. noting that the only conceivable rationalization of the senatorial apportionment scheme is that it was based on equal representation of political subdivisions within the state and is thus analogous to the federal Senate. The district court rejected that analogy on the ground that Alabama counties are merely involuntary political units of the state created by statute to aid in the administration of state government. In finding the so-called federal analogy irrelevant, the district court stated, "The analogy cannot survive the most superficial examination into the history of the requirement of the federal Constitution and the diametrically opposing history of the requirement of the Alabama Constitution that representation shall be based on population, nor can it survive a comparison of the different political natures of states and counties." The court also noted that the senatorial apportionment proposal may not have complied with the state constitution, since not only is it explicitly provided that the population basis of legislative representation shall not be changed by constitutional amendments, but the Alabama Supreme Court had previously indicated that that requirement could probably be altered only by constitutional convention. The court concluded, however, that the apportionment of seats in the Alabama House under the proposed constitutional amendment was based upon reason with a rational regard for known and accepted standards of apportionment. Under the proposed apportionment of representatives, each of the 67 counties was given one seat and the remaining 39 were allocated on a population basis. About 43% of the state's total population would live in counties which could elect a majority in that body. And under the provisions of the 67 Senator Amendment, while the maximum population variance ratio was increased to about 59-1 in the Senate, it was significantly reduced to about 4.7-1 in the House of Representatives. Jefferson County was given 17 seats in addition of 10. And Mobile County was allotted 8, an increase of 5. The increased representation of the urban counties was achieved primarily by limiting the state's 55 least populous counties to one House seat each, and the net effect was to take 19 seats away from rural counties and allocate them to the more populous counties. Even so, serious disparities from a population-based standard remained. Montgomery County, with 169,210 people, was given only 4 seats, while Coosa County, with a population of only 10,726, and Clyburn County, with only 10,911, were each allocated one representative. Turning next to the provisions of the Crawford-Webb Act, the district court found that its apportionment of the apportionment of the 106 seats in the Alabama House of Representatives by allocating one seat to each county and distributing the remaining 39 to the more populous counties in diminishing ratio to their populations was totally unacceptable. Under this plan, about 37% of the state's total population would reside in counties electing a majority of the members of the Alabama House, with a maximum population variance ratio of about 5-1. Each representative from Jefferson and Mobile counties would represent over 52,000 persons, while representatives from 8 rural counties would each represent less than 20,000 people. The court regarded the senatorial apportionment provided in the Crawford-Webb Act as a step in the right direction, but an extremely short step, and but a slight improvement over the present system of representation. The net effect of combining a few of the less populous counties into 2 county districts and splitting up several of the larger districts into smaller ones would be merely to increase the minority which would be represented by a majority of the members of the Senate from 25.1% to only 27.6% of the state's population. The court pointed out that under the Crawford-Webb Act, the vote of a person in the senatorial district consisting of Bibb and Perry counties would be worth 20 times that of a citizen in Jefferson County, and that the vote of a citizen in the 6 smallest districts would be worth 15 or more times that of a Jefferson County voter. The court concluded that the Crawford-Webb Act was totally unacceptable as a piece of permanent legislation, which, under the Alabama Constitution, would have remained in effect without alteration at least until after the next decennial census. Under the detailed requirements of the various constitutional provisions relating to the apportionment of seats in the Alabama Senate and House of Representatives, the court found the membership of the The membership of neither house can be apportioned solely on a population basis, despite the provision in Article 18, subsection 284, which states that representation in the legislature shall be based upon population. In dealing with the conflicting and somewhat paradoxical requirements under which the number of seats in the House is limited to 106, but each of the 67 counties is required to be given at least one representative, and the size of the Senate is limited to 35, but is required to have at least one-fourth of the members of the House, although no county can be given more than one senator. The district court stated its view that the controlling or dominant provision of the Alabama Constitution on the subject of representation in the legislature is the previously referred to language of subsection 284. The court stated that the detailed requirements of Article 9, subsections 197 through 200, make it obvious that in neither the House nor the Senate can representation be based strictly and entirely upon population. The result may well be that representation according to population, to some extent, must be required in both houses if invidious discrimination in the legislative systems as a whole is to be avoided. Indeed, it is the policy and theme of the Alabama Constitution to require representation according to population in both houses as nearly as may be, while still complying with more detailed provisions. The district court then directed its concern to the providing of an effective remedy. It indicated that it was adopting and ordering into effect for the November 1962 election a provisional and temporary reapportionment plan composed of the provisions relating to the House of Representatives contained in the 67 Senator Amendment and the provisions of the Crawford-Webb Act relating to the Senate. The court noted, however, that the proposed reapportionment of the Senate in the Crawford-Webb Act, unacceptable as a piece of permanent legislation, may not even break the stranglehold, stating that it was retaining jurisdiction and deferring any hearing on plaintiff's motion for a permanent injunction until the legislature, as provisionally reapportioned, has an opportunity to provide for a true reapportionment of both houses of the Alabama legislature. The court emphasized that its moderate action was designed to break the stranglehold by the smaller counties on the Alabama legislature and would not suffice as a permanent reapportionment. On July 25, 1962, the court entered its decree in accordance with its previously stated determinations, concluding that plaintiffs are denied equal protection by virtue of the debasement of their votes, since the legislature of the state of Alabama has failed and continues to fail to reapportion itself as required by law. It enjoined the defendant state officials from holding any future elections until any of the apportionment plans that it had found invalid, and stated that the 1962 election of Alabama legislatures could validly be conducted only under the apportionment scheme specified in the court's order. After the district court's decision, new primary elections were held pursuant to legislation enacted in 1962 at the same special session as the proposed constitutional amendment and the Crawford-Webb Act. To be effective in the event, the court itself ordered a particular reapportionment plan into immediate effect. The November 1962 general election was likewise conducted on the basis of the district court's ordered apportionment of legislative seats, as Mr. Justice Black refused to stay the district court's order. Consequently, the present Alabama legislature is apportioned in accordance with the temporary plan prescribed by the district court's decree. All members of both houses of the Alabama legislature serve 4-year terms, so that the next regularly scheduled election of legislatures will not be held until 1966. The 1963 regular session of the Alabama legislature produced no legislation relating to legislative apportionment, and the legislature, which means biennially, will not hold another regular session until 1965. No effective political remedy to obtain relief against the alleged malapportionment of the Alabama legislature appears to have been available. No initiative procedure exists under Alabama law. Amendment of the state constitution can be achieved only after a proposal is adopted by 3/5 of the members of both houses of the legislature and is approved by a majority of the people, or as a result of a constitutional convention convened after approval by the people of a convention call initiated by a majority of both houses of the Alabama legislature. Notices of appeal to this court from the district court's decision were timely filed by defendants below. appellants in number 23, and by two groups of intervener plaintiffs, cross appellants in numbers 27 and 41. Appellants in number 23 contend that the district court erred in holding the existing and the two proposed plans for the apportionment of seats in the Alabama legislature unconstitutional, and that a federal court lacks the power to affirmatively reapportion seats in a state legislature. Cross appellants in number 27 assert that the court below erred in failing to compel reapportionment of the Alabama Senate on a population basis as allegedly required by the Alabama Constitution and the Equal Protection Clause of the federal Constitution. Cross appellants in number 41 contend that the district court should have required and ordered into effect the apportionment of seats in both houses of the Alabama legislature on a population basis. We noted probable jurisdiction on June 10, 1963. Undeniably, the Constitution of the United States protects the right of all qualified citizens to vote in state as well as in federal elections. A consistent line of decisions by this court in cases involving attempts to deny or restrict the right of suffrage has made this indelibly clear. It has been repeatedly recognized that all qualified voters have a constitutionally protected right to vote and to have their votes counted. In Mosley, the United States v. Mosley. In Mosley, the court stated that it is as equally unquestionable that the right to have one's vote counted is as open to protection as the right to put a ballot in a box. The right to vote can neither be denied outright nor destroyed by alteration of ballots, nor diluted by ballot box stuffing. As the court stated in Classic, United States v. Classic. Obviously included within the right to choose, secured by the Constitution, is the right of qualified voters within a state to cast their ballots and have them counted. Racially based gerrymandering and the conducting of white primaries, both of which result in denying to some citizens their right to vote, have been held to be constitutionally impermissible. And history has seen a continuing expansion of the scope of the right of suffrage in this country. The right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any restrictions on that right strike at the heart of representative government. And the right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. In Baker v. Carr, we held that a claim asserted under the Equal Protection Clause challenging the constitutionality of a state's apportionment of seats in its legislature on the ground that the right to vote of certain citizens was effectively impaired since debased and diluted, in effect presented a justiciable controversy subject to adjudication by federal courts. The spate of similar cases filed and decided by lower courts since our decision in Baker amply shows that the problem of state legislative malapportionment is one that is perceived to exist in a large number of the states. In Baker, a suit involving an attack on the apportionment of seats in the Tennessee legislature, we remanded to the district court, which had dismissed the action for consideration on the merits. We intimated no view as to the proper constitutional standards for evaluating the validity of a state legislative apportionment scheme, nor did we give any consideration to the question of appropriate remedies. Rather, we simply stated, beyond noting that we have no cause at this stage to doubt the district court will be able to fashion relief if violations of constitutional rights are found, it is improper now to consider what remedy would be most appropriate if appellants prevail at the trial. We indicated in Baker, however, that the Equal Protection Clause provides discoverable and manageable standards for use by lower courts in determining the constitutionality of a state legislative apportionment scheme. And we stated, nor need the appellants, in order to succeed in this action, ask the court to enter upon policy determinations for which judicially manageable standards are lacking. Judicial standards under the Equal Protection Clause are well developed and familiar, and it has been open to courts since the enactment of the 14th Amendment to determine if on the particular facts they must, that a discrimination reflects no policy, but simply arbitrary and capricious action. Subsequent to Baker, we remanded several cases to the courts below for reconsideration in light of that decision. In Gray v. Sanders, we held that the Georgia County unit system, applicable in statewide primary elections, was unconstitutional since it resulted in a dilution of the weight of the votes of certain Georgia voters merely because of where they resided. After indicating that the 15th and 19th Amendments prohibit a state from overweighting or diluting votes on the basis of race or sex, we stated, how then can one person be given twice or 10 times the voting power of another person in a statewide election merely because he lives in a rural area or because he lives in the smallest rural county? Once the geographical unit for which a representative is to be chosen is designated, all who participate in the election are to have an equal vote, whatever their race, whatever their sex, whatever their occupation, whatever their income, and wherever their home may be in that geographical unit. This is required by the Equal Protection Clause of the 14th Amendment. The concept of we the people under the Constitution visualizes no preferred class of voters, but equality among those who meet the basic qualifications. The idea that every voter is equal to every other voter in his state when he casts his ballot in favor of one of several competing candidates underlies many of our decisions. Continuing, we stated that there is no indication in the Constitution that home site or occupation affords a permissible basis for distinguishing between qualified voters within the state. And finally, we conclude the conception of political equality from the Declaration of Independence to Lincoln's Gettysburg Address to the 15th, 17th, and 19th Amendments can mean only one thing: one person, one vote. We stated in Gray, however, that case, unlike Baker v. Carr, does not involve a question of the degree to which the Equal Protection Clause of the 14th Amendment limits the authority of a state legislature in designing the geographical districts from which representatives are chosen, either for the state legislature or for the federal House of Representatives. Nor does it present the question inherent in the bicameral form of our federal government, whether a state may have one house chosen without regard to population. Of course, in these cases, we are faced with the problem not presented in Gray, that of determining the basic standards and stating the applicable guidelines for implementing our decision in Baker v. Carr. In Westbury v. Sanders, decided earlier this term, we held that attacks on the constitutionality of congressional districting plans enacted by state legislatures do not present non-justiciable questions and should not be dismissed generally for want of equity. We determined that the constitutional test for the validity of congressional districting schemes was one of substantial equality of population among the various districts established by a state legislature for the election of members of the federal House of Representatives. In that case, we decided that an apportionment of congressional seats which contracts the value of some votes and expands that of others, contracts the value of some votes and expands that of others, is unconstitutional since the federal Constitution intends that when qualified voters elect members of Congress, each vote be given as much weight as any other vote. We concluded that the constitutional prescription for election of members of the House of Representatives by the people, construed in its historical context, means that as nearly as is practicable, one man's vote in a congressional election is to be worth as much as another's. We further stated, it would defeat the principles solemnly embodied in the Great Compromise, equal representation in the House for equal numbers of people, for us to hold that within the states, legislatures may draw the lines of congressional districts in such a way as to give some voters a greater voice in choosing a congressman than others. We found further in Westbury that our Constitution's plain objective was that of making equal representation for equal numbers of people the fundamental goal. Of making equal representation for equal numbers of people the fundamental goal. We concluded by stating, no right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. Our Constitution leaves no room for classification of people in a way that unnecessarily abridges this right. Gray and Westbury are, of course, not dispositive of or directly controlling on our decision in these cases involving state legislative apportionment controversies. Admittedly, those decisions in which we held that in statewide and in congressional elections, one person's vote must be counted equally with those of all other votes in a state, were based on different constitutional considerations and were addressed to rather distinct problems, but neither are they wholly inapposite. Gray, though not determinative here since involving the weighting of votes in statewide elections, established the basic principle of equality among voters within a state and held that voters cannot be classified constitutionally on the basis of where they live, at least with respect to voting in statewide elections. And our decision in Westbury was, of course, grounded on that language of the Constitution, which prescribes that members of the federal House of Representatives are to be chosen by the people, while attacks on legislative apportionment schemes, such as that involved in the instant cases, are principally based on the Equal Protection Clause of the 14th Amendment. Nevertheless, Westbury clearly established that the fundamental principle of representative government in this country is one of equal representation for equal numbers of people, without regard to race, sex, economic status, or place of residence within a state. Our problem, then, is to ascertain in the instant cases whether there are any constitutionally cognizable principles which would justify departures from the basic standard of equality among voters in the apportionment of seats in state legislatures. A predominant consideration in determining whether a state's legislative apportionment scheme constitutes an invidious discrimination violative of rights asserted under the Equal Protection Clause is that the rights allegedly impaired are individual and personal in nature. As stated by the court in United States v. Bathgate, the right to vote is personal, while the result of a court decision in a state legislative apportionment controversy may be to require the restructuring of the geographical distribution of seats in a state legislature. The judicial focus must be concentrated upon ascertaining whether there has been any discrimination against certain of the state's citizens, which constitutes an impermissible impairment of their constitutionally protected right to vote. Like Skinner v. Oklahoma, such a case touches a sensitive and important area of human rights, and involves one of the basic civil rights of man, presenting questions of alleged invidious discriminations against groups or types of individuals in violation of the constitutional guarantee of just and equal laws. Undoubtedly, the right of suffrage is a fundamental matter in a free and democratic society, especially since the right to exercise the franchise in a free and unimpaired manner is preservative of other basic civil and political rights, and any alleged infringement of the right of citizens to vote must be carefully and meticulously scrutinized. Almost a century ago, in Yick Wo v. Hopkins, the court referred to the political franchise of voting as a fundamental political right because preservative of all rights. Legislatures represent people, not trees or acres. Legislatures are elected by voters, not farms or cities or economic interests. As long as ours is a representative form of government, and our legislatures are those instruments of government elected directly by and directly representative of the people, the right to elect legislatures in a free and unimpaired fashion is a bedrock of our political system. It could hardly be gainsaid that a constitutional claim had been asserted by an allegation that certain otherwise qualified voters had been entirely prohibited from voting for members of their state legislature. And if a state should provide that the votes of citizens in one part of the state should be given 2 times, or 5 times, or 10 times the weight of votes of citizens in another part of the state, it could hardly be contended that the right to vote of those residing in the disfavored areas had not been effectively diluted. It would appear extraordinary to suggest that a state could be constitutionally permitted to enact a law providing that certain of the state's voters could vote 2, 5, or 10 times for their legislative representatives, while voters living elsewhere could vote only once. And it is inconceivable that a state law to the effect that in counting votes For legislatures, the votes of citizens in one part of the state would be multiplied by 2, 5, or 10, while the votes of persons in another area would be counted only at face value, could be constitutionally sustainable. Of course, the effect of state legislative districting schemes, which give the same number of representatives to unequal numbers of constituents, is identical. Overweighting and overvaluation of the votes of those living here has the certain effect of dilution and undervaluation of the votes of those living there. The resulting discrimination against those individual voters living in disfavored areas is easily demonstrable mathematically. Their right to vote is simply not the same right to vote as that of those living in a favored part of the state. 2, 5, or 10 of them must vote before the effect of their voting is equivalent to that of their favored neighbor. Weighting the votes of citizens differently by any method or means merely because of where they happen to reside hardly seems justifiable. Hardly seems justifiable. One must be ever aware that the Constitution forbids sophisticated as well as simple-minded modes of discrimination. As we stated in Westbury v. Sanders, we do not believe that the framers of the Constitution intended to permit the same vote-diluting discrimination to be accomplished through the device of districts containing widely varied numbers of inhabitants. To say that a vote is worth more in one district than in another would run counter to our fundamental idea of democratic government. State legislatures are historically the fountainhead of representative government in this country. A number of them have their roots in colonial times and substantially antedate the creation of our nation and our federal government. In fact, the first formal stirrings of American political independence are to be found in large part in the views and actions of several of the colonial legislative bodies. With the birth of our national government and the adoption and ratification of the federal Constitution, state legislatures retained a most important place in our nation's governmental structure. But representative government is in essence self-government through the medium of elected representatives of the people, and each and every citizen has an inalienable right to full and effective participation in the political processes of his state's legislative bodies. Most citizens can achieve this participation only as qualified voters through the election of legislatures to represent them. Full and effective participation by all citizens in state government requires, therefore, that each citizen have an equally effective voice in the election of members of his state legislature. Modern and viable state government needs, and the Constitution demands no less. Logically, in a society ostensibly grounded on representative government, it would seem reasonable that a majority of the people of a state could elect a majority of that state's legislatures. To conclude differently and to sanction minority control of the state legislative bodies would appear to deny majority rights in a way that far surpasses any possible denial of minority rights that might otherwise be thought to result. Since legislatures are responsible for enacting laws by which all citizens are to be governed, they should be bodies which are collectively responsive to the popular will. And the concept of equal protection has been traditionally viewed as requiring the uniform treatment of persons standing in the same relation to the governmental action questioned or challenged. With respect to the allocation of legislative representation, all voters, as citizens of a state, stand in the same relation regardless of where they live. And any suggested criteria for the differentiation of citizens are insufficient to justify any discrimination as to the weight of their votes unless relevant to the permissible purposes of legislative apportionment. Since the achieving of fair and effective representation for all citizens is concededly the basic aim of legislative apportionment, we conclude that the Equal Protection Clause guarantees the opportunity for equal participation by all voters in the election of state legislatures. Diluting the weight of votes because of place of residence impairs basic constitutional rights under the 14th Amendment. Just as much as invidious discrimination discriminates based upon factors such as race, Brown v. Board of Education, or economic status, Griffin v. Illinois, Douglas v. California. Our constitutional system amply provides for the protection of minorities by means other than giving them majority control of state legislatures. and the democratic ideals of equality and majority rule, which have served this nation so well in the past, are hardly of any less significance for the present and the future. We are told that the matter of apportioning representation in a state legislature is a complex and many-faceted one. We are advised that states can rationally consider factors other than population in apportioning legislative representation. We are admonished not to restrict the power of the states to impose differing views as to political philosophy on their citizens. We are cautioned about the dangers of entering into political thickets and mathematical quagmires. Our answer is this: a denial of constitutionally protected rights demands justicial protection. Our oath and our office require no less of us. As stated in Gomillion v. Lightfoot, when a state exercises power wholly within the domain of state interest, it is insulated from federal judicial review. But such insulation is not carried over when state power is used as an instrument for circumventing a federally protected right. To the extent that a citizen's right to vote is debased, he is that much less a citizen. The fact that an individual lives here or there is not a legitimate reason for overweighting or diluting the efficacy of his vote. The complexions of societies and civilizations change, often with amazing rapidity. A nation once primarily rural in character becomes predominantly urban. Representation schemes once fair and equitable become archaic and outdated. But the basic principle of representative government remains, and must remain, unchanged. The weight of a citizen's vote cannot be made to depend on where he lives. Population is, of necessity, the starting point for consideration and the controlling criterion for judgment in legislative apportionment controversies. A citizen, a qualified voter, is no more nor no less so because he lives in the city or on the farm. This is the clear and strong command of our Constitution's Equal Protection Clause. This is an essential part of the concept of a government of laws and not men. This is at the heart of Lincoln's vision of government of the people, by the people, and for the people. The Equal Protection Clause demands no less than substantially equal state legislative representation for all citizens, of all places as well as of all races. We hold that, as a basic constitutional standard, the Equal Protection Clause requires that the seats in both houses of a bicameral state legislature must be apportioned on a population basis. Simply stated, an individual's right to vote for state legislatures is unconstitutionally impaired when its weight is in a substantial fashion diluted when compared to the votes of citizens living in other parts of the state, since under neither the existing apportionment provisions nor either of the proposed plans was either of the houses of the Alabama legislature apportioned on a population basis. The district court correctly held that all three of these schemes were constitutionally invalid. Furthermore, the existing apportionment, and also to a lesser extent the apportionment under the Crawford-Webb Act, presented little more than crazy quilts, completely lacking in rationality, and could be found invalid on that basis alone. Although the district court presumably found the reapportionment of the Alabama House of Representatives under the 67 Senator Amendment to be acceptable, we conclude that the deviations from a strict population basis are too egregious to permit us to find that that body under this proposed plan was apportioned sufficiently on a population basis so as to permit the arrangement to be constitutionally sustained. Although about 43% of the state's total population would be required to comprise districts which could elect a majority in that body, only 39 of the 106 House seats were actually to be distributed on a population basis, as each of the Alabama's 67 counties was given at least one representative, and population variance ratios of close to 5-1 would have existed. While mathematical nicety is not a constitutional requisite, one could hardly conclude that the Alabama House, under the proposed constitutional amendment, had been apportioned sufficiently on a population basis to be sustainable under the requirements of the Equal Protection Clause, and none of the other apportionments of seats in either of the bodies of the Alabama legislature, under the three plans considered by the district court, came nearly as close to approaching the required constitutional standard as did that of the House of Representatives under the 67 Senator Amendment. Legislative apportionment in Alabama is signally illustrative and symptomatic of the seriousness of this problem in a number of the states. At the time this litigation was commenced, there had been no reapportionment of seats in the Alabama legislature for over 60 years. Legislative inaction, coupled with the unavailability of any political or judicial remedy, had resulted, with the passage of years, in a perpetuated scheme becoming little more than an irrational anachronism. A consistent failure by the Alabama legislature to comply with state constitutional requirements as to the frequency of reapportionment and the basis of legislative representation resulted in a minority stranglehold on the state legislature. Inequality of representation in one house added to the inequality in the other. With the crazy quilt existing apportionment virtually conceded to be invalid, the Alabama legislature offered two proposed plans for consideration by the district court, neither of which was to be effective until 1966, and neither of which provided for the apportionment of even one of the two houses on a population basis. We find that the court below did not err in holding that neither of these proposed reapportionment schemes, considered as a whole, meets the necessary constitutional requirements, and we conclude that the district court acted properly in considering these two proposed plans, although neither was to become effective until the 1966 election, and the proposed constitutional amendment was scheduled to be submitted to the state's voters in November 1962. Consideration by the court below of the two proposed plans was clearly necessary in determining whether the Alabama legislature had acted effectively to correct the admittedly existing malapportionment, and in ascertaining what sort of judicial relief, if any, should be afforded. Since neither of the houses of the Alabama legislature under any of the three plans considered by the district court was apportioned on a population basis, we would be justified in proceeding no further. However, one of the proposed plans that contained in the so-called 67 Senator Amendment, at least superficially, resembles the scheme of legislative representation followed in the federal Congress. Under this plan, each of Alabama's 67 counties is allotted one senator, and no counties are given more than one Senate seat. Arguably, this is analogous to the allocation of two Senate seats in the federal Congress to each of the 50 states, regardless of population. Seats in the Alabama House under the proposed constitutional amendment are distributed by giving each of the 67 counties at least one, with the remaining 39 seats being allotted among the more populous counties on a population basis. This scheme, at least at first glance, appears to resemble that prescribed for the Federal House of Representatives, where the 435 seats are distributed among the states on a population basis, although each state, regardless of its population, is given at least one congressman. Thus, although there are substantial differences in underlying rationale and results, the 67 Senator Amendment, as proposed by the Alabama legislature, at least arguably presents for consideration a scheme analogous to that used for apportioning seats in Congress. Much has been written since our decision in Baker v. Carr about the applicability of the so-called federal analogy to state legislative apportionment arrangements. After considering the matter, the court below concluded that no conceivable analogy could be drawn between the federal scheme and the apportionment of seats in the Alabama legislature under the proposed constitutional amendment. We agree with the district court and find the federal analogy inapposite and irrelevant to state legislative districting schemes. Attempted reliance on the federal analogy appears often to be little more than an after-the-fact rationalization offered in defense of maladjusted state apportionment arrangements. The original Constitution of 36 of our states provided that representation in both houses of the state legislatures would be based completely or predominantly on population, and the Founding Fathers clearly had no intention of establishing a pattern or model for the apportionment of seats in state legislatures when the system of representation in the federal Congress was adopted. Demonstrative of this is the fact that the Northwest Ordinance, adopted in the same year, 1787, as the federal Constitution, provided for the apportionment of seats in territorial legislatures solely on the basis of population. The system of representation in the two houses of the federal Congress is one ingrained in our Constitution, as part of the law of the land. It is one conceived out of compromise and concession, indispensable to the establishment of our federal republic. Arising from unique historical circumstances, it is based on the consideration that in establishing our type of federalism, a group of formerly independent states bound themselves together under one national government. Admittedly, the original The original 13 states surrendered some of their sovereignty in agreeing to join together to form a more perfect union. But at the heart of our constitutional system remains the concept of separate and distinct governmental entities, which have delegated some, but not all, of their formerly held powers to the single national government. The fact that almost three-fourths of our present states were never in fact independently sovereign does not detract from our view that the so-called federal analogy is inapplicable as a sustaining precedent for state legislative apportionments. The developing history and growth of our republic cannot cloud the fact that at the time of the inception of the system of representation in the federal Congress, a compromise between the larger and smaller states on this matter averted a deadlock in the Constitutional Convention, which had threatened to abort the birth of our nation. In rejecting an asserted analogy to the Federal Electoral College in Gray v. Sanders, we stated, "We think the analogies to the Electoral College, to districting and redistricting, and to other phases of the problems of representation in state or federal legislatures or conventions are inapposite." The inclusion of the Electoral College in the Constitution as the result of specific historical concerns validated the collegiate principle despite its inherent numerical inequality, but implied nothing about the use of an analogous system by a state in a statewide election. No such specific accommodation of the latter was ever undertaken, and therefore no validation of its numerical inequality ensued. Political subdivisions of states, counties, cities, or whatever never were and never have been considered as sovereign entities. Rather, they have been traditionally regarded as subordinate governmental instrumentalities created by the state to assist in the carrying out of state governmental functions. As stated by the court in Hunter v. City of Pittsburgh, these governmental units are created as convenient agencies for exercising such of the governmental powers of the state as may be entrusted to them, and the number, nature, and duration of the powers conferred upon them, and the territory over which they shall be exercised rests in the absolute discretion of the state. The relationship of the states to the federal government could hardly be less analogous. Thus, we conclude that the plan contained in the 67 Senator Amendment for apportioning seats in the Alabama legislature cannot be sustained by recourse to the so-called federal analogy. Nor can any other inequitable state legislative apportionment scheme be justified on such an asserted basis. This does not necessarily mean that such a plan is irrational or involves something other than a republican form of government. We conclude simply that such a plan is impermissible for the states under the Equal Protection Clause, since perforce resulting in virtually every case in submergence of the equal population principle in at least one house of a state legislature. Since we find the so-called federal analogy inapposite to a consideration of the constitutional validity of state legislative apportionment schemes, we necessarily hold that the Equal Protection Clause requires both houses of a state legislature to be apportioned on a population basis. The right of a citizen to equal representation and to have his vote weighed equally with those of all other citizens in the election of members of one house of a bicameral state legislature would amount to little if states could effectively submerge the equal population principle in the apportionment of seats in the other house. If such a scheme were permissible, an individual citizen's ability to exercise an effective voice in the only instrument of state government directly representative of the people might be almost as effectively thwarted as if neither house were apportioned on a population basis. Deadlock between the two bodies might result in compromise and concession on some issues, but in all too many cases, the more probable result would be the frustration of the majority will through minority veto in the House not apportioned on a population basis, stemming directly from the failure to accord adequate overall legislative representation to all of the state's citizens on a non-discriminatory basis. In summary, we can perceive no constitutional difference with respect to the geographical distribution of state legislative representation between the two houses of a bicameral state legislature. We do not believe that the concept of bicameralism is rendered anachronistic and meaningless when the predominant basis of representation in the two state legislative bodies is required to be the same: population. A prime reason for bicameralism, modernly considered, is to ensure mature and deliberate consideration of, and to prevent precipitation precipitate action on proposed legislative measures. Simply because the controlling criterion for apportioning representation is required to be the same in both houses does not mean that there will be no differences in the composition and complexion of the two bodies. Different constituencies can be represented in the two houses. One body could be composed of single-member districts, while the other could have at least some multi-member districts. The length of terms of the legislatures in the separate bodies could differ. The numerical size of the two bodies could be made to differ, even significantly, and the geographical size of districts from which legislatures are elected could also be made to differ. And apportionment in one house could be arranged so as to balance off minor inequities in the representation of certain areas in the other house. In summary, these and other factors could be and are presently in many states utilized to engender differing complexions and collective attitudes in the two bodies of a state legislature, although both are apportioned substantially on a population basis. By holding that as a federal constitutional requisite, both houses of a state legislature must be apportioned on a population basis. We mean that the Equal Protection Clause requires that a state make an honest and good faith effort to construct districts in both houses of its legislature as nearly of equal population as is practicable. We realize that it is a practical impossibility to arrange legislative districts so that each one has an identical number of residents or citizens or voters. Mathematical exactness or precision is hardly a workable constitutional requirement. In Westbury v. Sanders, the court stated that congressional representation must be based on population as nearly as is practicable. In implementing the basic constitutional principle of representative government, as enunciated by the court in Westbury, equality of population among districts, some distinctions may well be made between congressional and state legislative representation. Since almost invariably there is a significantly larger number of seats in state legislative bodies to be distributed within a state than congressional seats, it may be feasible to use political subdivision lines to a greater extent in establishing state legislative districts than in congressional districting, while still affording adequate representation to all parts of the state. To do so would be constitutionally valid so long as the resulting apportionment was one based substantially on population and the equal population principle was not diluted in any significant way. Somewhat more flexibility may therefore be constitutionally permissible with respect to state legislative apportionment than in congressional districting. Lower courts can and assuredly will work out more concrete and specific standards for evaluating state legislative apportionment schemes in the context of actual litigation. For the present, we deem it expedient not to attempt to spell out any precise constitutional tests. What is marginally permissible in one state may be unsatisfactory in another, depending on the particular circumstances of the case. Developing a body of doctrine on a case-by-case basis appears to us to provide the most satisfactory means of arriving at detailed constitutional requirements in the area of state legislative apportionment. Thus, we proceed to state here only a few rather general considerations which appear to us to be relevant. A state may legitimately desire to maintain the integrity of various political subdivisions insofar as possible and provide for compact districts of contiguous territory in designing a legislative apportionment scheme. Valid considerations may underlie such aims. Indiscriminate districting, without any regard for political subdivision or natural or historical boundary lines, may be little more than an open invitation to partisan gerrymandering. Single-member districts may be the rule in one state, while another state might desire to achieve some flexibility by creating multi-member or flotorial districts. Whatever the means of accomplishment, the overriding objective must be substantial equality of population among the various districts so that the vote of any citizen is approximately equal in weight to that of any other citizen in the state. History indicates, however, that many states have deviated to a greater or lesser degree from the equal population principle in the apportionment of seats in at least one house of their legislatures. So long as the divergences from a strict population standard are based on legitimate considerations incident to the effectuation of a rational state policy, some deviations from the equal population principle are constitutionally permissible with respect to the apportionment of seats in either or both of the two houses of a bicameral state legislature, but neither history alone nor economic or other sorts of group interests are permissible factors in attempting to justify disparities from population based representation. Citizens, not history or economic interests, cast votes. Considerations of area alone provide an insufficient justification for deviations from the equal population principle. Again, people, not land or trees or pastures, vote. Modern developments and improvements in transportation and communications make rather hollow in the mid 1960s most claims that deviations from population-based representation can validly be based solely on geographical considerations. Arguments for allowing such deviations in order to ensure effective representation for sparsely settled areas and to prevent legislative districts from becoming so large that the availability of access of citizens to their representatives is impaired are today, for the most part, unconvincing. A consideration that appears to be of more substance in justifying some deviations from population-based representation in state legislatures is that of ensuring some voice to political subdivisions, as political subdivisions. Several factors make more than insubstantial claims that a state can rationally consider according political subdivisions some independent representation in at least one body of the state legislature, as long as the basic standard of equality of population among districts is maintained. Local governmental entities are frequently charged with various responsibilities incident to the operation of state government. In many states, much of the legislature's activity involves the enactment of so-called local legislation, directed only to the concerns of particular political subdivisions. And a state may legitimately desire to construct districts along political subdivision lines to deter the possibilities of gerrymandering. However, permitting deviations from population-based representation does not mean that each local governmental unit or political subdivision can be given separate representation, regardless of population. Carried too far, a scheme of giving at least one seat in one house to each political subdivision, for example, to each county, could easily result in many states in a total subversion of the equal population principle in that legislative body. This would be especially true in a state where the number of counties is large and many of them are sparsely populated, and the number of seats in the legislative body being apportioned does not significantly exceed the number of counties. Such a result, we conclude, would be constitutionally impermissible, and careful judicial scrutiny must of course be given in evaluating state apportionment schemes to the character as well as the degree of deviations from a strict population basis. But if, even as a result of a clearly rational state policy, of according some legislative representation to political subdivisions, population is submerged as the controlling consideration in the apportionment of seats in the particular legislative body, then the right of all of the state's citizens to cast an effective and adequately weighted vote would be unconstitutionally impaired. One of the arguments frequently offered as a basis for upholding a state's legislative apportionment arrangement, despite substantial disparities from a population basis in either or both houses, is grounded on congressional approval incident to admitting states into the union of state apportionment plans containing deviations from the equal population principle. Proponents of this argument contend that congressional approval of such schemes, despite their disparities from population-based representation, indicates that such arrangements are plainly sufficient as establishing a Republican form of government. As we stated in Baker v. Carr, some questions raised under the Guarantee Clause are non-justiciable where political in nature and where there is a clear absence of judicially manageable standards. Nevertheless, it is not inconsistent with this view to hold that, despite congressional approval of state legislative apportionment plans at the time of admission into the Union, even though deviating from the equal population principle here enunciated, the Equal Protection Clause can and does require more. And an apportionment scheme in which both houses are based on population can hardly be considered as failing to satisfy the Guarantee Clause requirement. Congress presumably does not assume, in admitting states into the Union, to pass on all constitutional questions relating to the character of state governmental organization. In any event, congressional approval, however well considered, could hardly validate an unconstitutional state legislative apportionment. Congress simply lacks the constitutional power to insulate states from attack with respect to alleged deprivations of individual constitutional rights. That the Equal Protection Clause requires that both houses of a state legislature be apportioned on a population basis does not mean that states cannot adopt some reasonable plan for periodic revision of their apportionment schemes. Decennial reapportionment appears to be a rational approach to readjustment of legislative representation in order to take into account population shifts and growth. Reallocation of legislative seats every 10 years coincides with the prescribed practice in 41 of the states, often honored more in the breach than the observance, however. Illustratively, the Alabama Constitution requires decennial reapportionment, yet the last reapportionment of the Alabama legislature, when this suit was brought, was in 1901. Limitations on the frequency of reapportionment are justified by the need for stability and continuity in the organization of this legislative system. Although undoubtedly reapportioned no more frequently than every 10 years leads to some imbalance in the population of districts towards the end of the decennial period, and also to the development of resistance to change on the part of some incumbent legislatures. In substance, we do not regard the Equal Protection Clause as requiring daily, monthly, annual, or biennial reapportionment so long as the state has a reasonably conceived plan for periodic readjustment of legislative representation. While we do not intend to indicate that decennial reapportionment is a constitutional requisite, compliance with such an approach would clearly meet the minimal requirements for maintaining a reasonably current scheme of legislative representation, and we do not mean to intimate that more frequent reapportionment would not be constitutionally permissible or practically desirable. But if reapportionment were accomplished with less frequency, it would assuredly be constitutionally suspect. Although general provisions of the Alabama Constitution provide that the apportionment of seats in both houses of the Alabama legislature should be on a population basis, other more detailed provisions clearly make compliance with both sets of requirements impossible. With respect to the operation of the Equal Protection Clause, it makes no difference whether a state's apportionment scheme is embodied in its constitution or in statutory provisions. In those states where the alleged malapportionment has resulted from noncompliance with state constitutional provisions, which, if complied with, would result in an apportionment valid under the Equal Protection Clause, the judicial task of providing effective relief would appear to be rather simple. We agree with the view of the District Court that state constitutional provisions should be deemed violative of the federal Constitution only when validly asserted constitutional rights could not otherwise be protected and effectuated. Clearly, the courts should attempt to accommodate the relief ordered to the apportionment provisions of state constitutions insofar as possible, but it is also quite clear that a state legislative apportionment scheme is no less violative of the federal Constitution when it is based on state constitutional provisions which have been consistently complied with than when resulting from a noncompliance with state constitutional requirements. When there is an unavoidable conflict between the federal and a state constitution, the Supremacy Clause, of course, controls. We do not consider here the difficult question of the proper remedial devices which federal courts should utilize in state legislative apportionment cases. Remedial techniques in this new and developing area of the law will probably often differ with the circumstances of the challenged apportionment and a variety of local conditions. It is enough to say now that once a state's legislative apportionment scheme has been found to be unconstitutional, it would be the unusual case in which a court would be justified in not taking appropriate action to ensure that no further elections are conducted until under the invalid plan. However, under certain circumstances, such as where an impending election is imminent and a state's election machinery is already in progress, equitable considerations might justify a court in withholding the granting of immediately effective relief in a legislative apportionment case, even though the existing apportionment scheme was found invalid. In awarding or withholding immediate relief, a court is entitled to and should consider the proximity of a forthcoming election and the mechanics and complexities of state election laws, and should act and rely upon general equitable principles. With respect to the timing of relief, a court can reasonably endeavor to avoid a disruption of the election process, which might result from requiring precipitate changes that could make unreasonable or embarrassing demands on a state in adjusting to the requirements of the court's decree. As stated by Mr. Justice Douglas, concurring in Baker v. Carr, any relief accorded can be fashioned in the light of well-known principles of equity. We feel that the district court in this case acted in a most proper and commendable manner. It initially acted wisely in declining to stay an impending primary election in Alabama, and properly refrained from acting further until the Alabama legislature had been given an opportunity to remedy the admitted discrepancies in the state's legislative apportionment scheme, while initially stating some of its views to provide guidelines for legislative action. And it correctly recognized that legislative reapportionment is primarily a matter for legislative consideration and determination, and that judicial relief becomes appropriate only when a legislature fails to reapportion according to federal constitutional requisites in a timely fashion after having had an adequate opportunity to do so. Additionally, the court below acted with proper judicial restraint after the Alabama legislature had failed to act effectively in remedying the constitutional deficiencies in the state's legislative apportionment scheme in ordering its own temporary reapportionment plan into effect at a time sufficiently early to permit the holding of elections pursuant to that plan without great difficulty, and in prescribing a plan admittedly provisional in purpose so as to not usurp the primary responsibility for reapportionment which rests with the legislature. We find, therefore, that the action taken by the district court in this case in ordering into effect a reapportionment of both houses of the Alabama legislature for purposes of the 1962 primary and general elections by using the best parts of the two proposed plans, which it had found as a whole to be invalid, was an appropriate and well-considered exercise of judicial power. Admittedly, the lower court's ordered plan was intended only as a temporary and provisional measure, and the district court correctly indicated that the plan was invalid as a permanent apportionment. In retaining jurisdiction while deferring a hearing on the issuance of a final injunction, in order to give the provisionally reapportioned legislature an opportunity to act effectively, the court below proceeded in a proper fashion. Since the district court evinced its realization that its ordered reapportionment could not be sustained as the basis for conducting the 1966 election of Alabama legislatures, and avowedly intends to take some further action should the reapportioned Alabama legislature fail to enact a constitutionally valid permanent apportionment scheme in the interim, we affirm the judgment below and remand the cases for further proceedings consistent with the views stated in this opinion. Mr. Justice Clark, concurring in the affirmance, the court goes much beyond the necessities of this case in laying down a new equal population principle for state legislative apportionment. This principle seems to be an offshoot of Gray v. Sanders, i.e. one person, one vote, modified by the nearly as is practicable admonition of Westbury v. Sanders. Whether nearly as is practicable means one person, one vote, qualified by approximately equal or some deviations, or by the impossibility of mathematical nicety, is not clear from the majority's use of these vague and meaningless phrases. But whatever the standard, the court applies it to each house of the state legislature. It seems to me that all the court needs say in this case is that each plan considered by the trial court is a crazy quilt, clearly revealing invidious discrimination in each house of the legislature and therefore violative of the Equal Protection Clause. See my concurring opinion in Baker v. Carr. I therefore do not reach the question of the so-called federal analogy, but in my view, if one house of the state legislature meets the population standard, representation in the other house might include some departure from it so as to take into account on a rational basis other factors in order to afford some representation to the various elements of the state. See my dissenting opinion in Lucas v. 44th General Assembly of Colorado, decided this date. Mr. Justice Stewart, All of the parties have agreed with the district court's finding that legislative inaction for some 60 years in the face of growth and shifts in population has converted Alabama's legislative apportionment plan, enacted in 1901, into one completely lacking in rationality. Accordingly, for the reasons stated in my dissenting opinion in Lucas v. 44th General Assembly of Colorado, I would affirm the judgment of the district court holding that this apportionment violated the Equal Protection Clause. I also agree with the court that it was proper for the district court, in framing a remedy, to adhere as closely as practicable to the apportionments approved by the representatives of the people of Alabama, and to afford the state of Alabama full opportunity, consistent with the requirements of the federal Constitution, to devise its own system of legislative apportionment. Mr. Justice Harlan dissenting. In these cases, the court holds that seats in the legislature of 6 states are apportioned in ways that violate the federal Constitution. Under the court's ruling, it is bound to follow that the legislatures in all but a few of other 44 states will meet the same fate. These decisions, with Westbury v. Sanders, involving congressional districting by the states, and Gray v. Sanders, relating to elections for statewide office, have the effect of placing basic aspects of state political systems under the pervasive overlordship of the federal judiciary. Once again, I must register my protest. Today's holding is that the Equal Protection Clause of the 14th Amendment requires every state to structure its legislature so that all the members of each house represent substantially the same number of people. Other factors may be given play only to the extent that they do not significantly encroach on this basis population principle. Whatever may be thought of this holding as a piece of political ideology, and even on that score, the political history and practices of this country from its earliest beginnings leave wide room for debate. I think it demonstrable that the 14th Amendment does not impose this political tenet on the states or authorize this court to do so. The court's constitutional discussion, found in its opinion in the Alabama cases, and more particularly at pages 561 to 568 thereof, is remarkable, as indeed is that found in the separate opinions of my brothers Stewart and Clark. For its failure to address itself at all to the 14th Amendment as a whole, or to the legislative history of the amendment pertinent to the matter at hand, stripped of aphorisms, the court's argument boils down to the assertion that appellee's right to vote has been invidiously debased or diluted by systems of apportionment which entitle them to vote for fewer legislatures than other voters, an assertion which is tied to the Equal Protection Clause only by the constitutionally frail tautology that equal means equal. Had the court paused to probe more deeply into the matter, it would have found that the Equal Protection Clause was never intended to inhibit the states in choosing any democratic method they pleased for the apportionment of their legislatures. This is shown by the language of the 14th Amendment, taken as a whole, by the understanding of those who proposed and ratified it, and by the political practices of the states at the time the amendment was adopted. It is confirmed by numerous state and congressional actions since the adoption of the 14th Amendment, and by the common understanding of the amendment as evidenced by subsequent constitutional amendments and decisions of this court before Baker v. Carr make an abrupt break with the past in 1962. The failure of the court to consider any of these matters cannot be excused or explained by any concept of developing constitutionalism. It is meaningless to speak of constitutional development when both the language and history of the controlling provisions of the Constitution are wholly ignored. Since it can, I think, be shown beyond doubt that state legislative apportionments as such are wholly free of constitutional limitations, save such as may be imposed by the Republican form of government clause. See the Constitution, Article 4, subsection 4. The court's action now bringing them within the purview of the 14th Amendment amounts to nothing less than an exercise of the amending power by this court. So far as the federal Constitution is concerned, the complaints in these cases should all have been dismissed below for failure to state a cause of action, because what has been alleged or proved shows no violation of any constitutional right. Before proceeding to my argument, it should be observed that nothing done in Baker v. Carr or in the 2 cases that followed in its wake, Gray v. Sanders and Westbury v. Sanders, from which the court quotes at some length, forecloses the conclusion which I reach. Baker decided only that claims such as those made here are within the competence of the federal courts to adjudicate, although the court stated as its conclusion that the allegations of a denial of equal protection presented a justiciable constitutional cause of action. It is evident from the court's opinion that it was concerned all but exclusively with justiciability and gave no serious attention to the question whether the Equal Protection Clause touches state legislative apportionments. Neither the opinion of the court nor any of the concurring opinions considered the relevant text of the 14th Amendment or any of the historical materials bearing on that question. None of the materials was briefed or otherwise brought to the court's attention. In the Gray case, the court expressly laid aside the applicability to state legislative apportionments of the one-person, one-vote theory, there found to require the striking down of the Georgia county unit system, and the concurring opinion of Justice Stewart, see the U.S. 376, and the concurring opinion of Justice Stewart, joined by Clark. In Westbury, involving congressional districting, the decision rested on Article 1, subsection 2 of the Constitution. The court expressly did not reach the arguments put forward concerning the Equal Protection Clause. Thus, it seems abundantly clear that the court is entirely free to deal with the cases presently before it in light of materials now called to its attention for the first time. To these I now turn. The language of the 14th Amendment. The court relies exclusively on that portion of subsection 1 of the 14th Amendment which provides that no state shall deny to any person within its jurisdiction the equal protection of the laws, and disregards entirely the significance of subsection 2, which reads, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. The amendment is a single text. It was introduced and discussed as such in the Reconstruction Committee, which reported it to the Congress. It was discussed as a unit in Congress and proposed as a unit to the states, which ratified it as a unit. A proposal to split up the amendment and submit each section to the states as a separate amendment was rejected by the Senate. Whatever one might take to be the application to these cases of the Equal Protection Clause if it stood alone, I am unable to understand the court's utter disregard of the second section, which expressly recognizes the state's power to deny or in any way abridge the right of their inhabitants to vote for the members of the state legislature, and its express provision of a remedy for such denial or abridgment. The comprehensive scope of the second section and its particular reference to the state legislatures preclude the suggestion that the first section was intended to have the result reached by the court today. If indeed the words of the 14th Amendment speak for themselves, as the majority's disregard of history seems to imply, they speak as clearly as may be against the construction which the majority puts on them. But we are not limited to the language of the amendment itself. B. Proposal and ratification of the amendment. The history of the adoption of the 14th Amendment provides conclusive evidence that neither those who proposed nor those who ratified the amendment believed that the Equal Protection Clause limited the power of the states to apportion their legislatures as they saw fit. Moreover, the history demonstrates that the intention to leave this power undisturbed was deliberate and was widely believed to be essential to the adoption of the amendment. Proposal of the amendment in Congress. A resolution proposing what became the 14th Amendment was reported to both houses of Congress by the Reconstruction Committee of 15 on April 30th, 1866. The first two sections of the proposed amendment read, Section 1. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states which may be included within this union, according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But whenever in any state the elective franchise shall be denied to any portion of its male citizens not less than 21 years of age, or in any way abridged except for participation in rebellion or other crime, the basis of representation in such state shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens not less than 21 years of age. In the House, Thaddeus Stevens introduced debate on the resolution on May 8th. In his opening remarks, Stevens explained why he supported the resolution, although it fell far short of his wishes. I believe it is all that can be obtained in the present state of public opinion. Not only Congress, but the several states are to be consulted. Upon a careful survey of the whole ground, we did not believe that 19 of the loyal states could be induced to ratify any proposition more stringent than this. In explanation of his belief, he asked the House to remember that 3 months since and more, the committee reported and the House adopted a proposed amendment fixing the basis of representation in such way as would surely have secured the enfranchisement of every citizen at no distant period. But that proposal had been rejected by the Senate. He then explained the impact of the first section of the proposed amendment, particularly the Equal Protection Clause. This amendment allows Congress to correct the unjust legislation of the states so far that the law which operates upon one man shall operate equally upon all. Whatever law punishes a white man for a crime shall punish the black man precisely in the same way and to the same degree. Whatever law protects the white man shall afford equal protection to the black man. Whatever means of redress is afforded to one shall be afforded to all. Whatever law allows the white man to testify in court shall allow the man of color to do the same. These are great advantages over their present codes. Now different degrees of punishment are inflicted, not on account of the magnitude of the crime, but according to the color of the skin. Now color disqualifies a man from testifying in courts, or being tried in the same way as white men. I need not enumerate these partial and oppressive laws. Unless the Constitution should restrain them, those states will all, I fear, keep up this discrimination and crush to death the hated freedmen. He turned next to the second section, which he said he considered the most important in the article. Its effect, he said, was to fix the basis of representation in Congress. In unmistakable terms, he recognized the power of a state to withhold the right to vote. If any state shall exclude any of her adult male citizens from the elective franchise or abridge that right, she shall forfeit her right to representation in the same proportion. The effect of this provision will be either to compel the states to grant universal suffrage or so to shear them of their power as to keep them forever in a hopeless minority in the national government, both legislative and executive. Closing his discussion of the second section, he noted his dislike for the fact that it allowed the states to discriminate with respect to the right to vote among the same class and receive proportionate credit in representation. Toward the end of the debate, 3 days later, Mr. Bingham, the author of the first section in the Reconstruction Committee and its leading proponent, concluded his discussion of it with the following. Allow me, Mr. Speaker, in passing, to say that this amendment takes from no state any right that ever pertained to it. No state ever had the right, under the forms of law or otherwise, to deny to any freeman the equal protection of the laws or to abridge the privileges or immunities of any citizen of the Republic, although many of them have assumed and exercised the power, and that without remedy. The amendment does not give, as the second section shows, the power to Congress of regulating suffrage in the several states. He immediately continued. The second section excludes the conclusion that by the first section suffrage is subjected to congressional law, save indeed with this exception, that as the right in the people of each state to a republican government and to choose their representatives in Congress is of the guarantees of the Constitution. By this amendment, a remedy might be given directly for a case supposed by Madison, where treason might change a state government from a republican to a despotic government and thereby deny suffrage to the people. He stated at another point in his remarks, "To be sure, we all agree, and the great body of the people of this country agree, that the committee thus far in reporting measures of Reconstruction agree, that the exercise of the elective franchise, though it be one of the privileges of a citizen of the Republic, is exclusively under the control of the states. In the 3 days of debate which separate the opening and closing remarks, both made by members of the Reconstruction Committee, every speaker on the resolution, with a single doubtful exception, assumed without question that, as Mr. Bingham said, the second section excludes the conclusion that by the first section suffrage is subjected to congressional law. The assumption was neither inadvertent nor silent. Much of the debate concerned the change in the basis of representation effected by the second section, and the speakers stated repeatedly in express terms or by unmistakable implication that the states retained the power to regulate suffrage within their borders. Attached as Appendix A hereto are some of those statements. The resolution was adopted by the House without change on May 10th. Debate in the Senate began on May 23rd and followed the same pattern. Speaking for the Senate chairman of the Reconstruction Committee, who was ill, Senator Howard, also a member of the committee, explained the meaning of the Equal Protection Clause as follows. The last two clauses of the first section of the amendment disable a state from depriving not merely a citizen of the United States, but any person, whoever he may be, of life, liberty, or property without due process of law, or from denying to him the equal protection of the laws of the state. This abolishes all class legislation in the states and does away with the injustice of subjecting one caste of persons to a code not applicable to another. It prohibits the hanging of a black man for a crime for which the white man is not to be hanged. It protects the black man in his fundamental rights as a citizen with the same shield which it throws over the white man. It is not time, Mr. President, that we extend to the black man. I had almost called it the poor privilege of the equal protection of the law. But, sir, the first section of the proposed amendment does not give to either of these classes the right of voting. The right of suffrage is not, in law, one of the privileges or immunities thus secured by the Constitution. It is merely the creature of law. It has always been regarded in this country as the result of positive local law, not regarded as one of those fundamental rights lying at the basis of all society and without which a people cannot exist except as slaves subject to a despotism. Discussing the second section, he expressed his regret that it did not recognize the authority of the United States over the question of suffrage in the several states at all. He justified the limiting purpose of the amendment in this regard as follows. But, sir, is it not the question here, what will we do? It is not the question what you or I or half a dozen other members of the Senate may prefer in respect to colored suffrage. It is not entirely the question what measure we can pass through the two houses, but the question really is what will the legislatures of the various states to whom these amendments are to be submitted do in the premises? What is it likely will meet the general approbation of the people who are to elect the legislatures, 3/4 of whom must ratify our propositions before they have the force of constitutional provisions. The committee were of the opinion that the states are not yet prepared to sanction so fundamental a change as would be the concession of the right of suffrage to the colored race. We may as well state it plainly and fairly, so that there shall be no misunderstanding on the subject. It was our opinion that 3/4 of the states of this Union could not be induced to vote to grant the right of suffrage, even in any degree or under any restriction, to the colored race. The second section leaves the right to regulate the elective franchise still with the states and does not meddle with that right. There was not in the Senate, as there had been in the House, a closing speech in explanation of the amendment. But because the Senate considered and finally adopted several changes in the first and second sections, even more attention was given to the problem of voting rights there than had been given in the House. In the Senate, it was fully understood by everyone that neither the first nor the second section interfered with the right of the states to regulate the elective franchise. Attached as Appendix B here too are representative statements from the debate to that effect. After having changed the proposed amendment to the form in which it was adopted, the Senate passed the resolution on June 8, 1866. As changed, it passed in the House on June 13th. Ratification by the loyal states. Reports of the debates in the state legislatures on the ratification of the 14th Amendment are not generally available. There is, however, compelling indirect evidence of the 23 loyal states which ratified the amendment before 1870. 5 had constitutional provisions for apportionment of at least one house of their respective legislatures, which wholly disregarded the spread of population. 10 more had constitutional provisions which gave primary emphasis to population, but which applied to other principles, such as partial ratios and recognition of political subdivisions, which were intended to favor sparsely settled areas. Can it be seriously contended that the legislatures of these states, almost 2/3 of those concerned, would have ratified an amendment which might render their own states' constitutions unconstitutional? Nor were these state constitutional provisions merely theoretical. In New Jersey, for example, Cape May County, with a population of 8,349, and Ocean County, with a population of 13,628, each elected one state senator, as did Essex and Hudson counties, with populations of 143,839 and 129,067 respectively. In the House, each county was entitled to one representative, which left 39 seats to be apportioned according to population. Since there were 12 counties besides the 2 already mentioned, which had populations over 30,000, it is evident that there were serious disproportions in the House also. In New York, each of the 60 counties except Hamilton County was entitled to one of the 128 seats in the Assembly. This left 69 seats to be distributed among counties, the populations of which ranged from 15,420 to 942,292, with 7 more counties having populations over 100,000 and 13 others having populations over 50,000. The disproportion in the Assembly was necessarily large. In Vermont, after each county had been allocated one senator, there were 16 seats remaining to be distributed among the larger counties. The smallest county had a population of 4,082. The largest had a population of 40,651, and there were 10 other counties with populations over 20,000. Ratification by the reconstructed states. Each of the 10 reconstructed states was required to ratify the 14th Amendment before it was remitted to the Union. The constitution of each was scrutinized in Congress. Debates over readmission were extensive. In at least one instance, the problem of state legislative apportionment was expressly called to the attention of Congress. Objecting to the inclusion of Florida in the Act of June 25, 1868, Mr. Farnsworth stated on the floor of the House, "I might refer to the apportionment of representatives. By this Constitution, representatives in the legislature of Florida are apportioned in such a manner as to give to the sparsely populated portions of the state the control of the legislature. The sparsely populated parts of the state are those where there are very few African Americans, and the parts inhabited by the white rebels, the men who, coming in from Georgia, Alabama, and other states, control the fortunes of their several counties. By this Constitution, every county in that state is entitled to a representative. There are in that state counties that have not 30 registered voters. Yet, under this Constitution, every one of those counties is entitled to a representative in the legislature, while the populous counties are entitled to only one representative each, with an additional representative for every 1,000 inhabitants." The response of Mr. Butler is particularly illuminating. All these arguments, all these statements, all the provisions of this Constitution have been submitted to the Judiciary Committee of the Senate, and they have found the Constitution Republican and proper. This Constitution has been submitted to the Senate, and they have found it Republican and proper. It has been submitted to your own Committee on Reconstruction, and they have found it Republican and proper, and have reported it to this House. The constitutions of 6 of the 10 states contained provisions departing substantially from the method of apportionment now held to be required by the amendment, and as in the North, the departures were as real in fact as in theory. In North Carolina, 90 of the 120 representatives were apportioned among the counties without regard to population, leaving 30 seats to be distributed by numbers. Since there were 7 counties with populations under 5,000 and 26 counties with populations over 15,000, the disproportions must have been widespread and substantial. In South Carolina, Charleston, with a population of 88,863, elected 2 senators. Each of the other counties with populations ranging from 10,269 to 42,486 elected 1 senator. In Florida, each of the 39 counties was entitled to elect 1 representative. No county was entitled to more than 4. These principles applied to Dade County with a population of 85 and to Alachua County and Leon County, with populations of 17,328 and 15,236 respectively. It is incredible that Congress would have exacted ratification of the 14th Amendment as the price of readmission, would have studied the state constitutions for compliance with the amendment, and would then have disregarded violations of it. The facts recited above show beyond any possible doubt, 1, that Congress, with full awareness of and attention to the possibility that the states would not afford full equality in voting rights to all their citizens, nevertheless deliberately chose not to interfere with the state's plenary power in this regard when it proposed the 14th Amendment. 2, that Congress did not include in the 14th Amendment restrictions on the state's power to control voting rights because it believed that if such restrictions were included, the amendment would not be adopted. And 3, that at least a substantial majority, if not all, of the states which ratified the 14th Amendment did not consider that in doing so they were accepting limitations on their freedom, never before questioned, to regulate voting rights as they chose. Even if one were to accept the majority's belief that it is proper entirely to disregard the unmistakable implications of the second section of the amendment, in construing the first section, one is confounded by its disregard of all this history. There is here none of the difficulty which may attend the application of basic principles to situations not contemplated or understood when the principles were framed. The problems which concern the court now were problems when the amendment was adopted. By the deliberate choice of those responsible for the amendment, it left those problems untouched. After 1868. The years following 1868, far from indicating a developing awareness of the applicability of the 14th Amendment to problems of apportionment, demonstrate precisely the reverse, that the states retained and exercised the power independently to apportion their legislatures. In its constitutions of 1875 and 1901, Alabama carried forward earlier provisions guaranteeing each county at least 1 representative and fixing an upper limit to the number of seats in the House. Florida's Constitution of 1885 continued to the guarantee of 1 representative for each county and reduced the maximum number of representatives per county from 4 to 3. Georgia, in 1877, continued to favor the smaller counties. Louisiana, in 1879, guaranteed each parish at least 1 representative in the House. In 1890, Mississippi guaranteed each county 1 representative, established a maximum number of representatives, and provided that specified groups of counties should each have approximately 1/3 of the seats in the House, whatever the spread of population. Missouri's Constitution of 1875 gave each county 1 representative and otherwise favored less populous areas. Montana's original Constitution of 1889 apportioned the state Senate by counties. In 1877, New Hampshire amended its constitution's provisions for apportionment but continued to favor sparsely settled areas in the House and to apportion seats in the Senate according to direct taxes paid. The same was true of New Hampshire's Constitution of 1902. In 1894, New York adopted a constitution, the peculiar apportionment provisions of which were obviously intended to prevent representation according to population. No county was allowed to have more than 1/3 of all the senators. No 2 counties which were adjoined or separated only by public waters could have more than 1/2 of all the senators. And whenever any county became entitled to more than 3 senators, the total number of senators was increased, thus preserving to the small counties their original number of seats. In addition, each county
except Hamilton, was guaranteed a seat in the Assembly. The North Carolina Constitution of 1876 gave each county at least one representative and fixed a maximum number of representatives for the whole House. Oklahoma's constitution at the time of its admission to the Union, 1907, favored small counties by the use of partial ratios and a maximum number of seats in the House. In addition, no county was permitted to take part in the election of more than 7 representatives. Pennsylvania in 1873 continued to guarantee each county one representative in the House. The same was true of South Carolina's Constitution of 1895, which provided also that each county should elect one and only one senator. Utah's original Constitution of 1895 assured each county of one representative in the House. Wyoming, when it entered the Union in 1889, guaranteed each county at least one senator and one representative. Today, since the court now invalidates the legislative apportionments in 6 states and has so far upheld the apportionment in none, it is scarcely necessary to comment on the situation in the states today, which is, of course, a fully contrary to the court's decision, as is the record of every prior period in this nation's history. As of 1961, the constitutions of all but 11 states, roughly 20% of the total, recognized bases of apportionment other than geographic spread of population and to some extent favored sparsely populated areas by a variety of devices, ranging from straight area representation or guaranteed minimum area representation to complicated schemes of the kind exemplified by the provisions of New York's Constitution of 1894, still in effect until struck down by the court today in number 20. Since Tennessee, which was the subject of Baker v. Carr, and Virginia, scrutinized and disapproved today in number 69, are among the 11 states whose own constitutions are sound from the standpoint of the federal constitution as construed today, it is evident that the actual practice of the states is even more uniformly than their theory opposed to the court's view of what is constitutionally permissible. Other factors. In this summary of what the majority ignores, note should be taken of the 15th and 19th Amendments. The former prohibited the states from denying or abridging the right to vote on account of race, color, or previous condition of servitude. The latter, certified as part of the Constitution in 1920, added sex to the prohibited classifications. In Minor v. Happersett, this court considered the claim that the right of women to vote was protected by the Privileges and Immunities Clause of the 14th Amendment. The court's discussion there of the significance of the 15th Amendment is fully applicable here with respect to the 19th Amendment as well. And still again, after the adoption of the 14th Amendment, it was deemed necessary to adopt the 15th as follows. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The 14th Amendment had already provided that no state should make or enforce any law which should abridge the privileges or immunities of citizens of the United States. If suffrage was one of these privileges or immunities, why amend the Constitution to prevent its being denied on account of race? Nothing is more evident than that the greater must include the less. And if all were already protected, why go through with the form of amending the Constitution to protect a part? In this present case, we can go still further. If constitutional amendment was the only means by which all men and later women could be guaranteed the right to vote at all, even for federal officers, how can it be that the far less obvious right to a particular kind of apportionment of state legislatures, a right to which is opposed a far more plausible conflicting interest of the state than the interest which opposes the general right to vote, can be conferred by judicial construction of the 14th Amendment. Yet, unless one takes the highly implausible view that the 14th Amendment controls methods of apportionment, but leaves the right to vote itself unprotected, the conclusion is inescapable that the court has, for purposes of these cases, relegated the 15th and 19th Amendments to the same limbo of constitutional anachronisms to which the second section of the 14th Amendment has been assigned. Mention should be made finally of the decisions of this court which are disregarded or, more accurately, silently overruled today. Minor v. Happersett, in which the court held that the 14th Amendment did not confer the right to vote on anyone has already been noted. Other cases are more directly in point. In Colgrove v. Barrett, this court dismissed, for want of a substantial federal question, an appeal from the dismissal of a complaint alleging that the Illinois legislative apportionment resulted in gross inequality in voting power and gross and arbitrary and atrocious discrimination in voting, which denied the plaintiffs equal protection of the laws. In Remy v. Smith, a three-judge district court dismissed a complaint alleging that the apportionment of the Pennsylvania legislature deprived the plaintiffs of constitutional rights guaranteed to them by the 14th Amendment. The district court stated that it was aware of the plaintiffs' allegations were notoriously true and that the practical disenfranchisement of qualified electors in certain of the election districts in Philadelphia County is a matter of common knowledge. Let me redo that. The practical disenfranchisement of qualified electors in certain of the election districts in Pennsylvania, in certain districts of Philadelphia County, is a matter of common knowledge. This court dismissed the appeal for the want of a substantial federal question. In Kidd v. McCandless, the Supreme Court of Tennessee dismissed an action for a declaratory judgment that the Tennessee Apportionment Act of 1901 was unconstitutional. The complaint alleged that a minority of approximately 37% of the voting population of the state now elects and controls 20 of the 33 members of the Senate. That a minority of 40% of the voting population of the state now controls 63 of the 99 members of the House of Representatives. Without dissent, this court granted the motion to dismiss the appeal. In Radford v. Gary, a three-judge district court was convened to consider the complaint of the plaintiff to the effect that the existing apportionment statutes of the state of Oklahoma violate the plain mandate of the Oklahoma Constitution and operate to deprive him of the equal protection of the laws guaranteed by the 14th Amendment to the Constitution of the United States. The plaintiff alleged that he was a resident and voter in the most populous county of the state, which had about 15% of the total population of the state, but only about 2% of the seats in the state Senate and less than 4% of the seats in the House. The complaint recited the unwillingness or inability of the branches of the state government to provide relief and alleged that there was no state remedy available. The district court granted a motion to dismiss. This court affirmed without dissent. Each of these recent cases is distinguished on some ground or other in Baker v. Carr. Their summary dispositions prevent consideration whether these after-the-fact distinctions are real or imaginary. The fact remains, however, that between 1947 and 1957, 4 cases raising issues precisely the same as those decided today were presented to the court. 3 were dismissed because the issues presented were thought insubstantial, and in the 4th, the lower court's dismissal was affirmed. I have tried to make the catalog complete, yet to keep it within the manageable limits of a judicial opinion. In my judgment, today's decisions are refuted by the language of the amendment which they construe and by the inference fairly to be drawn from subsequently enacted amendments. They are unequivocally refuted by history and by consistent theory and practice from the time of the adoption of the 14th Amendment until today. The court's elaboration of its new constitutional doctrine indicates how far and how unwisely it has strayed from the appropriate bounds of its authority. The consequence of today's decision is that in all but the handful of states which may already satisfy the new requirements, the local district court, or it may be the state courts, are given blanket authority and the constitutional duty to supervise apportionment of the state legislatures. It is difficult to imagine a more intolerable and inappropriate interference by the judiciary with the independent legislatures of the states. In the Alabama cases, numbers 23, 27, and 41, the district court held invalid not only existing provisions of the state constitution, which this court lightly dismisses with a wave of the supremacy clause and the remarked that it makes no difference whether a state's apportionment scheme is embodied in its constitution or in statutory provisions, but also a proposed amendment to the Alabama Constitution, which had never been submitted to the voters of Alabama for ratification, and standby legislation which was not to become effective unless the amendment was rejected or declared unconstitutional, and in no event before 1966. Now, both of these measures had been adopted only 9 days before, at an extraordinary session of the Alabama legislature convened pursuant to what was very nearly a directive of the district court. The district court formulated its own plan for the apportionment of the Alabama legislature by picking and choosing among the provisions of the legislative measures. Beyond that, the court warned the legislature that there would be still further judicial reapportionment unless the legislature, like it or not, undertook the task for itself. This court now states that the district court acted in a most proper and commendable manner and approves the district court's avowed intention of taking some further action unless the state legislature acts by 1966. In the Maryland case, number 29, the state legislature was called into special session and enacted a temporary reapportionment of the House of Delegates under the pressure from the state courts. Thereafter, the Maryland Court of Appeals held that the Maryland Senate was constitutionally apportioned. This court now holds that neither branch of the state legislature meets constitutional requirements. The court presumes that since the Maryland constitutional provisions relating to legislative apportionment are hereby held unconstitutional, the Maryland legislature has the inherent power to enact at least temporary reapportionment legislation pending adoption of state constitutional provisions which satisfy the federal constitution. On this premise, the court concludes that the Maryland courts need not feel obliged to take further affirmative action now, but that under no circumstances should the 1966 election of members of the Maryland legislature be permitted to be conducted pursuant to the existing or any other unconstitutional plan. In the Virginia case, number 69, the state legislature in 1962 complied with the state constitutional requirement of regular reapportionment. 2 days later, a complaint was filed in the district court. 8 months later, the legislative reapportionment was declared unconstitutional. The district court gave the state legislature 2 months within which to reapportion itself in special session under penalty of being reapportioned by the court. Only a stay granted by a member of this court slowed the process. It is plain that no stay will be forthcoming in the future. The Virginia legislature is to be given an adequate opportunity to enact a valid plan, but if it fails to act promptly in remedying the constitutional defects in the state's legislative apportionment plan, the district court is to take further action. In Delaware, number 307, the district court entered an order on July 25th, 1962, which stayed proceedings until August 7th, 1962, in the hope and expectation that the General Assembly would take some appropriate action in the intervening 13 days. By way of prodding, presumably, the court noted that if no legislative action were taken and the court sustained the plaintiff's claim, the present General Assembly and any subsequent General Assembly, the members of which were elected pursuant to Section 2 of Article 2, the challenged provisions of the Delaware Constitution might be held not to be a de jure legislature, and its legislative acts might be held invalid and unconstitutional. 5 days later, on July 30th, 1962, the General Assembly approved a proposed amendment to the state constitution. On August 7th, 1962, the district court entered an order denying the defendant's motion to dismiss. The court said that it did not wish to substitute its judgment for the collective wisdom of the General Assembly of Delaware, but that in the light of all the circumstances, it had to proceed promptly. On October 16, 1962, the court declined to enjoin the conduct of elections in November. The court went on to express its regret that the General Assembly had not adopted the court's suggestion that the Delaware Constitution be amended to make apportionment a statutory rather than a constitutional matter so as to facilitate further changes in apportionment which might be required. In January 1963, the General Assembly again approved the proposed amendment of the apportionment provisions of the Delaware Constitution, which thereby became effective on January 17, 1963. 3 months later, on April 17, 1963, the district court reached the reluctant conclusion that Article 2, subsection 2 of the Delaware Constitution was unconstitutional with or without the 1963 amendment. Observing that the state of Delaware, the General Assembly, and this court all seemed to be trapped in a kind of box of time, the court gave the General Assembly until October 1st, 1963, to adopt acceptable provisions for apportionment. On May 20th, 1963, the district court enjoined the defendants from conducting any elections, including the general election scheduled for November 1964, pursuant to the old or the new constitutional provisions. This court now approves all these proceedings, noting particularly that in allowing the 1962 elections to go forward, the district court acted in a wise and temperate manner. Records such as these in the cases decided today are sure to be duplicated in most of the other states if they have not been already. They present a jarring picture of courts threatening to take action in an area which they have no business entering, inevitably on the basis of political judgments which they are incompetent to make. They show legislatures of the states meeting in haste and deliberating and deciding in haste to avoid the threat of judicial interference. So far as I can tell, the court's only response to this unseemly state of affairs is ponderous insistence that a denial of constitutionally protected rights demands judicial protection, by thus refusing to recognize the bearing which a potential for conflict of this kind may have on the question whether the claimed rights are in fact constitutionally entitled to judicial protection, the court assumes, rather than supports its conclusion. It should by now be obvious that these cases do not mark the end of reapportionment problems in the courts. Predictions once made that the courts would never have to face the problem of actually working out an apportionment have proved false. This court, however, continues to avoid the consequences of its decisions, simply assuring us that the lower courts can and will work out more concrete and specific standards, deeming it expedient not to spell out precise constitutional tests. The court contents itself with stating only a few rather general considerations. Generalities cannot obscure the cold truth that cases of this type are not amendable to the development of judicial standards. No set of standards can guide a court which has to decide how many legislative districts a state shall have, or what the shape of the districts shall be, or where to draw a particular district line. No judicially manageable standard can determine whether a state should have single-member districts or multi-member districts, or some combination of both. No such standard can control the balance between keeping up with population shifts and having stable districts. In all these respects, the court will be called upon to make particular decisions with respect to which a principle of equally populated districts will be of no assistance whatsoever. Quite obviously, there are limitless possibilities for districting consistent with such a principle, nor can these problems be avoided by judicial reliance on legislative judgments so far as possible. Reshaping or combining one or two districts, or modifying just a few district lines, is no less a matter of choosing among many possible solutions, with varying political consequences, than reapportionment broadside. The court ignores all this, saying only that what is marginally permissible in one state may be unsatisfactory in another, depending on the particular circumstances of the case. It is well to remember that the product of today's decision will not be readjustment of a few districts in a few states, which most glaringly depart from the principle of equally populated districts. It will be a redetermination, extensive in many cases, of legislative districts in all but a few states. Although the court necessarily, as I believe, provides only generalities in elaboration of its main thesis, its opinion nevertheless fully demonstrates how far removed these problems are from fields of judicial competence. Recognizing that indiscriminate districting is an invitation to partisan gerrymandering, the court nevertheless excludes virtually every basis for the formation of electoral districts other than indiscriminate districting. In one or another of today's opinions, the court declares it unconstitutional for a state to give effective consideration to any of the following in establishing legislative districts: history, economic, or other sorts of group interests, area, geographic considerations, a desire to ensure effective representation for sparsely settled areas, availability of access of citizens to the representatives, theories of bicameralism, except those approved by the court, occupation, an attempt to balance urban and rural power, the preference of a majority of voters in the state. So far as presently appears, the only factor which a state may consider, apart from numbers, is political subdivisions. But even a clearly rational state policy recognizing this factor is unconstitutional if population is submerged as the controlling consideration. I know of no principle of logic or practical or theoretical politics, still less any constitutional principle which establishes all or any of these exclusions. Certain it is that the court's opinion does not establish them. So far as the court says anything at all on this score, it says only that legislators represent people, not trees or acres, that citizens, not history or economic interest, cast votes, that people, not land or trees or pastures, vote. All this may be conceded. But it is surely equally obvious, and in the context of elections, more meaningful to note that people are not ciphers and that legislatures can represent their electors only by speaking for their interests, economic, social, political, many of which do reflect the place where the electors live. The court does not establish, or indeed even attempt to make, a case for the proposition that conflicting interests within a state can only be adjusted by disregarding them when voters are grouped for purposes of representation. Conclusion. With these cases, the court approaches the end of the third round set in motion by the complaint filed in Baker v. Carr. What is done today deepens my conviction that judicial entry into this realm is profoundly ill-advised and constitutionally impermissible. As I have said before, Westbury v. Sanders, I believe that the vitality of our political system, on which, in the last analysis, all else depends, is weakened by reliance on the judiciary for political reform. In time, a complacent body politic may result. These decisions also cut deeply into the fabric of our federalism. What must follow from them may eventually appear to be the product of state legislatures. Nevertheless, no thinking person can fail to recognize that the aftermath of these cases, however desirable it may be thought in itself, will have been achieved at the cost of a radical alteration in the relationship between the states and the federal government, more particularly the federal judiciary. Only one who has an overbearing impatience with the federal system and its political processes will believe that cost was not too high or was inevitable. Finally, these decisions give support to the current mistaken view of the Constitution and the constitutional function of this court. This view, in a nutshell, is that every major social ill in this country can find its cure in some constitutional principle, and that this court should take the lead in promoting reform when other branches of government fail to act. The Constitution is not a panacea for every blot upon the public welfare, nor should this court, ordained as a judicial body, be thought of as a general haven for reform movements. The Constitution is an instrument of government, fundamental to which is the premise that in a diffusion of governmental authority lies the greatest promise that this nation will realize liberty for all its citizens. This court, limited in function in accordance with that premise, does not serve its high purpose when it exceeds its authority even to satisfy justified impatience with the slow workings of the political process. For when, in the name of constitutional interpretation, the court adds something to the Constitution that was deliberately excluded from it, the court, in reality, substitutes its views of what should be so for the amending process. I dissent in each of these cases, believing that in none of them have the plaintiffs stated a cause of action, to the extent that Baker v. Carr expressly or by implication went beyond a discussion of jurisdictional doctrines independent of the substantive issues involved here. It should be limited to what it in fact was, an experiment in venturesome constitutionalism. I would reverse the judgment of the district court in numbers 23, 27, and 41, for Alabama, number 69 for Virginia, and number 307 for Delaware, and remand with directions to dismiss the complaints. I would affirm the judgment of the district courts in number 20, New York, and number 508, Colorado, and of the Court of Appeals of Maryland in number 29. And then this is just the appendix of the statements at the time of the ratification, so you're welcome to read those as you like. Other than that, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments, and we'd be happy to take a look. Thank you.